Hello, everyone, and welcome. Thank you all for joining Foley and Lardner for today's presentation, Creditor Remedies and Securities and Exchange Commission Receiverships, Everything You Ever Wanted to Program. And now I will turn it over to Jill Nicholson to introduce today's presenters.
Thanks so much, Lauren. Welcome, everyone. My name is Jill Nicholson. I'm a partner in Foley's Bankruptcy and Restructuring Group out of Chicago. And along with me, my co-presenter, Andrew McLean, who is an associate in Chicago, who specializes in litigation, creditors' rights, and commercial real estate matters. So today we're going to be talking about everything you wanted to know about SEC receiverships. And, it seems like a very kind of narrow band or narrow topic, but a lot of the principles that we'll be talking about also apply to federal equity receiverships generally. This is one of the areas that I think people don't appreciate can impact creditors beyond just investors in the particular entity. And frankly, this can happen to any industry. So what we're going to be talking about today is the why and how of these SEC receiverships, how creditors, and this will have a distinctly creditor-based focus, this presentation, how you enforce your contractual remedies and the treatment of creditor claims, and then how assets get disposed of in SEC receiverships. It is very much a unique animal, something that you don't see all the time, is becoming more and more prevalent. Next slide, please. So let's talk about the why and how and the scope, because I think a fundamental understanding of how these work will help you figure out how you want to enforce your remedies if you're ever caught up in one of these particular scenarios. Next slide, please. I included this slide because I thought it was interesting to see how many active SEC receiverships are currently pending throughout the United States. So there are 112 right now, pending in 26 states. And a little bit of a caveat to that is sometimes these cases last a couple years. Sometimes they can last a decade. They are not short-lived, typically speaking. They tend to be long, drawn-out, and somewhat difficult proceedings that often don't have a very quick end to the story. As you can see, 7 states account for 68% of the total receiverships. That's not surprising. So, for example, the lion's share you'll see in California, followed up by Texas and Florida. The great state of Illinois has 4, as well as Minnesota, and they're really widespread in terms of you can see them in Utah, and I didn't identify all the states, but 26 states, quite a few where we've seen these proceedings commenced. Next slide, please. So where are they filed and how are they filed? Looks like we may have been put on by a participant, so thank you. Okay, so one of the things that you'll see is that they're filed in federal district courts. So in the United States district courts, you won't see them anywhere else because the SEC receivership is a federal statute. The key to remember about them is that it's an equitable proceeding. There's limited statutory guidance, and the treatment varies circuit by circuit and judge by judge. And just before we commenced the call, we were talking with some of the attendees about how we've had disparate treatment between in front of the same judge in 2 SEC receivership cases that particular judge is handling. So there is, I wish I could say like bankruptcy, there's a framework and a just general understanding of how things work. I'd like to say this is kind of like the Wild West. You don't know what's going to happen until you walk into it. The judge has significant authority to fashion remedies. And for many of you who are familiar with bankruptcy or participate in bankruptcy cases, you have some basic understanding. You have the rubric of the bankruptcy code, which facilitates everyone's understanding of how the rules are and how the game is played. And again, here in this instance, you really don't have that. Bear in mind, there's no size limitation for an SEC receivership. It could be a handful of creditors with minimal claims or de minimis claims, or even thousands of creditors with billions of dollars in claims. Andrew and I were recently involved in an SEC receivership pending in New York, where you had secured creditors with $2 billion worth of claims at least. tied up into that, hundreds of property, commercial real estate properties. So it's something that, don't think it's just a little guy that gets tagged with an SEC receivership. Next slide, please. Now, this is something I want to underscore. The SEC identifies individuals and entities violating securities laws. That's the threshold matter. Typically, what will happen is an organization, a company, an individual will be investigated, usually behind the scenes. There'll be some kind of outreach in which the SEC says, okay, we want to dig in a little bit deeper. But what you often see is that there is no one particular industry that is impacted more than the other. And we see this often, and especially lately, commercial real estate. We also have oil and gas SEC receiverships, pharma, manufacturing, and professional services even. Anything where you have a lie or fraud to investors can be something that triggers an SEC's receivership. And I can tell you right now, in the last 2 years, we've seen 3 commercial real estate SEC receiverships, and frankly, the SEC seems to be very high on bringing those. Next slide. So let's talk a little bit about some of the cases that we've seen to help you get an understanding of where or why these cases might be filed. In Morgan acquisitions, this was a matter that we were actively involved in. Morgan provided or solicited investors with subordinated unsecured loans to basically develop or acquire commercial real estate, and often provided or promised high guaranteed rates of return. So we have a commercial real estate instance there. Biochemics was a little bit different. In that case, it was a transdermal drug delivery company that actually misrepresented to investors that certain products were under FDA review. JCS Enterprises said that they would create freestanding virtual concierge machines, kind of like you see that would when you check into a hotel, but that these would create ad revenue, and really at the end of the day, those concierge machines weren't even being developed. They were just siphoning funds from investors. And then Illinois Stock Transfer Company, which was one that is near and dear to my heart, in which I served as the court-appointed SEC receivership. That was an instance where you had a stock transfer agency where the company was supposed to be distributing dividends and administering DRIPs, and providing records of shareholder meetings, et cetera, for publicly traded companies, and instead had created what was called a miscellaneous clearing account, where all the funds were funneled, which should have been segregated, were funneled into a single account and then just doled out. It was basically a Ponzi scheme that I spent operating, coming in and stepping in and removing all the owner and the officers and running that and eventually winding that down. But that's something, even if you're a bystander, if you're involved with just even having an outside vendor or provider where they can get caught up in these kinds of instances. And a word to the wise, if you ever are trying to avoid any investigation of fraud, never name a financial account miscellaneous. That was when talking to the SEC, that was the red flag that they had. Never mind that this company had not paid federal or state taxes in 10 years. What the SEC honed in on was that they had what was called a miscellaneous clearing account. When they said, tell us about that, there was really no good explanation. Next slide. So what's the purpose of these SEC receiverships? Obviously it's to protect investors who are being defrauded, but it's also to enjoin securities violations, and also to prevent waste and dissipation of assets. So for example, there's only a fixed amount of funds typically in these cases, and many times you have the owners or the individuals or the companies lining their pockets with investor funds. That's very typical with lavish homes or other kinds of things that you would expect in that kind of fraud scenario. I have to say, in my case, the owner was not actually lining his pockets, but just got into trouble. And as I mentioned to before we got started, Michael, that I had a partner in our securities group who said that sometimes people start digging a 6-inch hole and it winds up being a 6-foot grave. Meaning that once that fraud starts, it's very hard to unwind and recover from that. Transparency. So it gives transparency to the process because it is a federal equity receivership and it is in court. There are a number of reporting, reports, financial documents that need to be submitted, and those are often publicly available. So you know exactly, whether you're a creditor or an investor, what is happening. There's also a process which we'll talk about a little later during the presentation where assets are distributed to claimants and investors. And this is where the SEC receivership often and frequently digresses from what you may know as a bankruptcy priority process. It's basically turned on its head in an SEC receivership. And finally, to perform functions as directed by the court. If you look at an SEC receiver, they're basically a fiduciary of the court designed to carry out the will of the court and to facilitate either the shutdown or the disposition of the assets. Next slide, please. Okay. I particularly like this slide because I think visually it summarizes what we're about to talk to you about. Creditors, unlike investors, often get caught in the crosshairs of an equitable proceeding that wasn't really meant to protect creditors, but was meant to protect investors. Next slide. So why does this matter to you? I've talked a little bit about how this starts and what the purpose is. Yeah, for example, if your contractual counterparty, you may be doing business with an entity or individual where their business is caught in an SEC receivership and a business may cease. Contracts can be rejected. So if you're a contractual counterparty, you may have this expectation of a 5-year contract, whether it's in manufacturing or elsewhere, that may no longer exist and may be rejected, leaving you, with a supply chain problem or perhaps just a large unsecured claim or damages. Assets may be seized. So you may have assets that are being utilized by your counterparty that may be subject to forfeiture, and we'll talk about that at the very end of the presentation, something to think about. Like bankruptcy, also an automatic stay is imposed by order of the court, and that is broad sweeping and the purview is extremely wide. If you're a lender, for our lender clients and attendees on the call, you may have a secured or unsecured credit that you're offering. And so what happens is there's usually a battle between investors and lenders and unsecured creditors over the limited assets. And like bankruptcy, if you're a secured creditor, your liens can be avoided as fraudulent transfers under the applicable state fraudulent transfer laws. So this is just a tip of the iceberg as to why creditors, whether secured or unsecured, need to think about, or contractual counterparties need to think about why these SEC receiverships are important and how to navigate them deftly. Next slide. So how does it begin? So the SEC investigates fraud, and that can take years, months. It's a time-consuming process. The target is not aware of it. It's behind the scenes. And then what will happen is a lawsuit, once it's determined that they've established enough evidence to determine that there was fraud, a lawsuit will be filed in federal district court. And typically it's filed under seal. So the defendant, whoever the target is not notified immediately of the lawsuit. And that is commenced, and the court will take a look at it and say, okay, we think there's adequate information. Ultimately, that complaint will be unsealed, but the thought is when the receiver goes in to take custody and control, the target has no idea that this is about to happen. So the SEC concurrently or within a few weeks after the complaint is filed will file a motion to appoint a receiver. And again, that can be ex parte or not. I've seen it done both ways, where the SEC will publicly file the motion to appoint the receiver, or will go in without any public attending to say this is who we want to be a receiver. Typically, the way it works is, and I can tell you, I wasn't even invited to the motion to appoint the receiver, and they typically are not. So I'm not even privy as a receiver to the appointment process before the court if it's not publicly open. The SEC will make some recommendations and say this is the person we prefer, but we have other candidates. And then the court will make a decision. And even sometimes the court will have the ability to say, I don't like any of these candidates you've put forth. I have some other thoughts. Or does this person have the expertise or the understanding of this particular industry or area to do an adequate job? So there's some give and take there as to whom is ultimately selected. Once that receivership order is entered, the receiver goes in and takes over the business. In my case, what we did was we called the local police department to attend, and we just showed up. And we put everybody in a conference room, all the employees, the owner, and explained that we had been appointed and that the CEO and owner was relieved of his duties. And then we immediately started taking information and names down and trying to figure out, really, most importantly, who were the bad guys and who were the good guys. And that's something you may not necessarily know just from what the SEC has disclosed to you. So it's an interesting process and one that really involves an element of surprise. So why do I share this with you? Because 9 times out of 10, you will also have the element of surprise, which is all of a sudden things are going well and you find that, wow, there's an SEC receivership. I don't know what that is. What does that mean for me? And you're tied up. And typically it's a whirlwind because trying to get a hold of the receiver or even the receiver's counsel can be challenging the first few days. Next slide. Now, the receiver stands in the shoes of the defendant, so carries the mantle, I should say, of whatever rights and liabilities that the defendant has, and will displace existing ownership and management. Particularly noteworthy is the SEC can waive the attorney-client privilege in litigation. So, as I mentioned, the receiver is an officer of the court, and more particularly is not an employee of the SEC, and is a fiduciary for all parties in interest. So you say, well, it's appointed by the SEC. I mean, think about a number of you on the call who are here today where you've gotten receivers in place, whether it be commercial real estate or otherwise. The lender gets to pick. Like this, the SEC gets to pick. But remember that the receiver is a fiduciary for all of the parties in interest. And as the SEC likes to describe them, is as a neutral third party. Now, that's in theory, but I have to tell you, the SEC receiver does work very closely with the SEC in terms of formulating responses, what is appropriate, what the SEC views as appropriate, and takes that into consideration. The SEC can't control the receiver, but certainly whatever opinions the SEC has are weighed very heavily. Next slide. So the order appointing the receiver is the key document here. It's very broad in nature. Sometimes it's 12, 15, 20 pages long, and it really defines the receiver's duties. What can the receiver do or not do? So if you're looking to find out, the first thing you want to do as a creditor is get your hands on a copy of that SEC order. And I can tell you, I've never seen that order overturned. I've never seen the liabilities or limitations placed on the receiver overturned. It can be amended to be broadened, but I certainly have never seen that order limited in scope. And I like to call it the receiver's playbook and basically guidelines for parties of interest. So if you're wondering how you're being impacted, pull a copy of that receiver order and you'll see just exactly how broad it is. Next slide, please. So what are common receiver responsibilities? Well, first of all, going in and identifying assets, which might include some of your assets. If there are bailments or other kinds of contractual arrangements, figuring out what does the receivership entity own, the estate, or what do you own? Notifying creditors of the pending receivership, operating or shutting down the business. Clearly, the SEC receiver is not designed to continue the business ad infinitum. Instead, it's usually a stopgap measure to dispose of the assets to another entity. And I would say, frankly, the vast majority of these receiverships, the entities are shut down before the receiver is even appointed. In our case with IST, the stock transfer case, I basically took a leave of absence from Foley for about 3 months to run that company and work to dispose of the assets and make sure that the clearing functions and the related distributions were being made until we could sell that off to another stock transfer agent. It's very encompassing and time-consuming process. The receiver also administers claims. Like a bankruptcy case, you'll have, and we'll talk about this later, proofs of claim that need to be filed, and the receiver will take a look at them and then make a distribution plan. The receiver has the ability to sue you as a creditor or as a contractual counterparty, and also has to provide periodic accountings and reports to the court. Next slide. Now, again, who selects the receiver? It's the SEC. We talked a little bit about this. The court ultimately has the decision-making authority, and I can't overemphasize how much the selection of the receiver is critical to how you are treated. And again, I believe Andrew will talk about this later, but in the case where we had two different SEC receiverships, one of my clients was paid in full with one receivership, one receiver, and in the other instance, we're still waiting to get paid with the other receiver. Some are very talented and very focused and able to handle these cases very in a streamlined way, and others it's just a recipe for disaster, and you're left waiting with your hands out with no real resolution. Next slide. This is important for creditors as well. You wonder, how is the receiver paid, especially if the entity is closed down? Well, there are quarterly fee applications that are reviewed by the district court, and parties have an opportunity to object, but the pot of funds available to the receiver, basically any assets that come into the receivership estate. So for example, if you have funds that aren't held in trust, those could be used to pay the receiver. If you have cash flowing commercial properties that are throwing off NOI, that can be used to pay the receiver, and they're deemed administrative expenses. In fact, we have situations now where the receiver is trying to prime or get priority over secured lender security interests. So oftentimes, if you're a creditor, every dollar that's spent by the receiver as an administrative expense will ultimately come out of your pocket. That's why it's very important to monitor the expenses that the receivership is incurring and to object where appropriate. And I hate to say this, it can be very lucrative for an SEC receiver. In a case we're involved in right now, where there's a lawyer, a law firm, not Foley, of course, but handling the matter, he and his law firm were billing $7,000 a day in legal fees on what I would call a low to mid-size SEC receivership, with the court's blessing and imprimatur, and also with the SEC's imprimatur. And even the investors have become frustrated with the level of fees that are being incurred in that case. Next slide. I thought this slide, I put it together because I thought it would be helpful for those of you who are familiar with bankruptcy to really understand how the disparate treatment and the similarities between an SEC receivership and a bankruptcy. So both have the automatic stay. Both have a plan process. So that is for distributing assets. But I would say that the bankruptcy plan process is far more robust, reliable, and predictable. The plan process basically provides in an SEC receivership limited statutory guidance. It is all case law based. So you could go from, the 7th Circuit to the 11th Circuit to the 9th Circuit in California, and have disparate treatment of basically the same kind of creditor claims. There's no rubric for you to follow in an SEC receivership typically. You can have fraudulent transfer claims. In bankruptcy, they're under both the bankruptcy code and state law. Under an SEC receivership, that is state law based only, but state law can vary for the statutes of limitations. It could be 2 years, 4 years, 6 years, and in some cases, there is no statute of limitations for fraudulent transfers. Like the bankruptcy code, you can have the priming of secured creditors or lenders. That is much more difficult to do in bankruptcy than it is in an SEC receivership. There's no creditors committees in an SEC receivership, but you also have assignment, rejection, and also assumption of contracts, which you would also have in a bankruptcy case. But unlike, again, bankruptcy, where you have specific statutory requirements like adequate protection or adequate assurance of future performance and curing of defaults. You don't really see that in an SEC receivership. And finally, the sale of assets. Yes, again, a 363 sale or planned sale. In an SEC receivership, it's typically done by motion, and you make up the rules as you go along. There's no real formula, rhyme, or reason. It's simply what is reasonable. And that depends on, the person you talk to. Next slide. Now let's talk about, you're now tied up. You understand how an SEC receivership works. You know the limitations. You're tied up into it. What does it look like now? How do you enforce your remedies? Next slide. One thing is understanding the stay and the asset freeze. So the receiver order stays and enjoins anyone or anything with direct or indirect control over any receivership assets. And the receivership assets can be defined extremely broadly. Parties are also stayed from transferring, setting off, pledging, liquidating. This is just like a bankruptcy court stay. Very broad in nature and self-enforcing. So the minute that receiver order goes into place, it doesn't matter whether you know about it or not. If you take actions in derogation of the receiver order, that would be deemed void, and you would either have to return funds or go back to the status quo as it was before you took those post-receiver order actions. Next slide. So one of the issues that if you look at the red language, you can't interfere with the receiver's efforts to take control or possession. You can't hide assets. You can't, if there's something that the receiver needs to use to operate the business, then you need to provide that. For those who are on the call and involved in commercial real estate, you can't accelerate the loan or mortgage or declare a default. And for those of you, just a little helpful tip, in the commercial real estate side, remember, acceleration often triggers yield maintenance or prepayment premium. So the problem is, if you're stayed from accelerating, you might be trying to file a claim for yield maintenance and are stayed from doing so, like you would in a bankruptcy with an SEC receivership. And I always say, if you're in a default scenario, always accelerate, because you can always reinstate and deaccelerate later. You don't want to risk being precluded from obtaining prepayment premiums or yield maintenance. Next slide. Here are the practical effects of the stay or the freeze. You can't set off. As I mentioned, you can't exercise default remedies. You can't collect on judgments if you're pursuing someone. So let's say they're in breach of a contract that you have with them. You can't continue with that litigation. The bank accounts are all retitled in the receivership name. One of the key things that you have to do as a receiver is take those assets and immediately transfer title to make sure that no one is sweeping or setting off. And that's particularly important to know if you are a secured lender. Next slide. Guarantor issues. This is just amazing to me because the stay is actually broader in an SEC receivership than it is in bankruptcy. Only in Chapter 13, which is an individual-based bankruptcy, would you have a co-debtor stay. Here, it would apply to even those folks, past guarantors and defendants, past or present, including officers or managers or agents, involved with that particular entity. So, typically in bankruptcy, the only one that has the benefit of the automatic stay is the entity who's filed a petition or is placed in involuntary bankruptcy. But here, it's much broader in scope. Next slide. Statute of limitations, something to think about. Let's say you're a counterparty and you are in dispute with a party that's in an SEC receivership. The statute of limitations for a lawsuit against you is told by order of the receiver order. So you're stuck, I hate to say it, what I like to call a virtual purgatory in terms of if there are going to be counterclaims or breach of contract or fraudulent transfers. We're in a case right now where we're almost 3 years into the case and we're requesting that the receiver file actions to assert any kind of equitable subordination or fraudulent transfers, and court is not compelling the receiver to do it, and frankly, there's the statute of limitations that's running because it's told simply by the existence of the receiver order. Next slide. Anticipate the stay. Now, this is always easier said than done, and I always hate when lawyers give advice that's really not practical, but this is something where you can take advice that doesn't seem practical and actually make it practical. And what do I mean by that? If you're sensing, I always say, if you trust your senses on this, if something seems awry or wrong or just not right, you're usually onto something. So what I would say is look for red flags. What I would tell you is include any disclosures by the counterparty of any SEC related inquiries or especially site visits. If you get into the situation or scenario where there are site visits that are out of the ordinary, you should be seeing a red flag. One of the issues is you can take those actions, you can enforce your rights pre-receivership, but once that receivership starts, the music stops and there's nothing for you to do absent getting relief from that order, which is extremely difficult to do. I have to tell you, if you're a lender, there's all kinds of litigation as to whether you set off before the receiver order was entered. And that could come down to issue of minutes. We've seen that where the receiver order is entered at 3:02 p.m. on a Tuesday and the set off was, 3:04 p.m. on that Tuesday. It really can come down to a matter of minutes. Next slide. You can obtain relief from the district court, just like you could in bankruptcy, but unlike bankruptcy, there are no articulated grounds for doing so. That's basically essentially a cause standard. Does it make sense? You're not getting adequate protection. There's no single asset real estate exception to the stay. There's no post-petition ongoing performance of contracts exception to the stay. So you have to basically make your own law going forward if you're looking for relief. Next slide. Here's a point that I think where bankruptcy and SEC receiverships converge. It's very difficult to get relief from a stay, whether in bankruptcy or a receivership, early on or kind of in the nascent stages of the case. For example, the receiver often has limited information about the assets, the business, and frankly, that information could be outdated. We see where the SEC may be investigated 6 months ago or 3 months ago, but those assets could have been depleted since then. You don't have a heads up. You can't go in and interview the entity beforehand because there's the element of surprise. So if you go into a district court saying, I need relief immediately, the odds of you getting turned down are very high because basically the court wants to give the receiver an opportunity to investigate and get its arms around what exactly is happening before it's willing to just let creditors go in and start dismantling the company. Next slide. Again, this is the same. This picture, I love this picture because it depicts exactly what you're trying to do if you're trying to get relief early on in the case. Next slide. Filing a claim, you need to file a claim in the case, and there's no particular statutory way to do it. There's no one set form. It varies case by case, and unlike bankruptcy, the receiver can ask for all kinds of information, underwriting files, correspondence, documentation. So if you find yourself filing that, you'll want to negotiate an NDA or other confidentiality provision to make sure that your information is not being disseminated to others publicly. Next slide. The other issue is understand your contract rights. You can be compelled to perform services without payment post-receivership. Let me say that again. You can be forced to provide goods and services without payment post-receivership if the court deems it necessary and essential. This is an issue that is highly litigated and is extremely troublesome to clients because why would you ever do that if you're not getting paid for that? Like I had one client who said they likened SEC to having the powers of God with the court signing off on it. It's just one of those situations where you'll be stuck in litigation and if necessary, provide that. My view was very different when I was an SEC receiver. If someone was providing me goods and services post-petition, that needed to be paid for in the ordinary course. So for example, where we had outside databases that we relied on to make sure we had accurate information to investors, we paid those rather than have risk litigation having that access shut off automatically. Next slide. Rejection of contracts. Your contracts can be rejected, meaning that the receivership will no longer abide by them and will leave you with an unsecured claim in damages, meaning that good luck. If they're cents on the dollar, that's maybe what you get. Does the receiver have to affirmatively go out and notify you that it's rejecting your contract? Unfortunately, the answer is no in some jurisdictions. In bankruptcy, there has to be a form or a motion filed saying, I'm rejecting this contract in my business discretion. Here, very informal. If they're not performing, maybe it's deemed rejected, maybe it's not. A tip to the wise here, if you're tied up and you have a contract, you need to understand and get with the Receivers Counsel immediately to find out what the intent of that the receiver is with respect to your contract. Just don't let it idle, because you might be running up fees and other costs that you'll never be able to recover. Next slide. These are just a couple examples of the standard for rejection, and how much time the receiver's given. You know, in bankruptcy, there are scenarios where you have a window to be able to make a decision here, just on the discretion of the court. Next slide. So with this, I'm going to turn it over to Andrew McLean to talk about treatment of claims.
Thank you, Jill. So similar to a bankruptcy, as Jill mentioned earlier, the creditors and any claimants will have to submit proofs of claim, although there is one caveat to that we'll get into in a little bit. Next slide, please. So once you submit your claim, then the receiver will have an opportunity to review those claims, and the receiver can object to those claims. And as a result of that, there might be litigation related to your claim. And some examples of why the receiver might object: he or she might object to your claim being secured, might object to the amount of your claim, might object to the validity of your claim, might try and equitably subordinate your claim. And that will all be done through the claims process. And unfortunately, it may be difficult to counter the receiver's objections for a host of reasons. We include a couple here. For instance, the documents or electronic records that might help you defend against the objections may have been destroyed by the bad actors and the defendants. The documents might be too voluminous and too expensive to access. Jill and I have had experience with that, where the receiver has attempted to prevent the creditors and claimants from obtaining access to documents under the guise that it is too expensive to grant us access. The employees with knowledge of information related to the objections or the claims may have been terminated. There might not be any remaining institutional knowledge that you can seek to gather through any sort of discovery process. So that would ultimately hurt your ability to respond to the objections. And then finally, there might be delay due to the receiver's inexperience with business or the assets that are the nature of the case. Sometimes these cases are extremely complicated. The receiver might not have a particular set of skills related to the actual operation of the business, which all goes back to the point of the SEC ultimately chooses a receiver, and sometimes you might get a really experienced receiver, or you might get a receiver who is a deer in the headlights. Next slide, please. And one unique thing about the receivership proceedings is the claims process can proceed under a summary proceedings type litigation. And what I mean by that is it's a truncated, shortened proceeding compared to the typical plenary proceeding that you would see in a normal litigation. For instance, if you file a complaint, you serve the complaint, there's an answer, and then you're off with your normal litigation. There's discovery, there's dispositive motions and things like that. But in a receivership, the receiver can propose a claims process that's a summary proceeding, meaning you might not have the opportunity to do robust discovery. You might not even have the opportunity to do dispositive motions. And what I mean by that is a motion to dismiss or a motion for summary judgment. And the reason for this is sometimes there's a large group of investors or claimants, and the most effective way to resolve the claims process is through a summary proceedings rather than a long, drawn-out plenary litigation. One thing to note, though, is you're still entitled to due process. And so there is significant amount of case law related to the creditors and investors' rights when there is a summary proceeding proposed. And you're entitled to the necessary information and a meaningful opportunity to be heard. That sounds simpler than it actually is, because as we'll get into in a second, there might be limits on what information you are actually entitled to, what opportunity to be heard you're actually given. Next slide, please. And this is what I mean by my last point. So the devil is in the details. We've had instances where the receivers tried to limit discovery to simply 10 interrogatories, or limit discovery to one deposition. And obviously that will greatly affect your ability to defend your case, will affect your ability to provide a robust defense. So you need to pay attention to the proposed claims process, object to it if necessary. As I alluded to earlier, we've had receivers withhold information due to alleged costs. Again, this could implicate due process concerns. And then Jill mentioned it earlier, there might be even a failure to provide specific details or the mechanisms to defend against claims filed by the receiver. So for instance, if the receiver files a fraudulent transfer claim, your ability to defend against that might be significantly impacted by the parameters of the claims process. Same thing for an equitable subordination claim, meaning the receiver is going to attempt to knock you down in the line of priority, and as well as a potential breach of contract claim against the receiver would bring against you. Next slide, please. And this is what I was referring to earlier when I said you might not always need to submit a proof of claim. There is case law that says the district court cannot extinguish a secured claim as a result of that party's failure to file a proof of claim by the claims bar date. But importantly to note is the unsecured portion of the claim can be extinguished if you don't file the proof of claim. So to the extent you intend to share in any unsecured pool of assets for a deficiency claim or the like, if you don't file a proof of claim, you might miss out on that opportunity to share in the pro rata portion of the unsecured pool of assets. Next slide, please. And there's a very commonly quoted progeny of case law that says the receiver takes the property subject to all liens, priorities, or privileges existing or accruing under the laws of the state. Now that sounds very simple. Okay, the receiver, for instance, if it's a receivership that involves a lot of commercial real estate, the receiver takes all of that real estate subject to any mortgages or liens that are recorded against those properties. But it's a little more nuanced than that. Does this really mean what it says? And I'll get into this later, but if the receiver goes to sell the property on which you have a lien, the receiver can sell that property, and now your lien is removed from that collateral and it attaches to the sale proceeds. Well, now all of a sudden, this clause that says the receiver takes property subject to your lien doesn't have as much teeth, because instead of having a security interest in collateral that you can foreclose, take possession of, and then potentially sell on the back end, now all of a sudden you're limited to a finite pot of money, meaning the sale proceeds from the sale of your collateral. Next slide, please. And Jill alluded to this earlier. We've had two SEC receiverships before the exact same judge in the Northern District of Illinois, and two very, very different outcomes in terms of how the receiver is operated, how creditors are paid off. One case was extremely cooperative. We received a full payoff in about a year and a half from filing of the complaint, appointment of receiver, to sale of the collateral. The other case has been going on for almost 3 years now. We have not received a penny on any payment, and that includes P&I payments. So the Northridge case is obviously the good example. That case, it involved, as many of them do, a Ponzi type scheme. It involved commercial real estate, and we ultimately received a full payoff from the sale of those properties with minimal litigation. There was a significant amount of negotiations with the receiver, but ultimately it concluded with a full payoff. And notably, during that case, P&I payments were consistently made throughout the receivership. Now, compare it to another case that Jill and I are involved in, the equity build case, where no P&I payments have been made for over 3 years. Just an example of how different this case is. At the outset, there were approximately 150 commercial properties, commercial real estate properties, and the receiver was using funds from property A, using rents generated from property A to pay expenses for property B, notwithstanding the fact that property A was encumbered by a mortgage and assignment of leases and rents in favor of one creditor, and property B was encumbered by a mortgage, assignment of leases and rents in favor of another creditor. So essentially he was robbing Peter to pay Paul, and what we argued was continuing the same Ponzi scheme that landed the defendants before the court in the first place. Jill alluded to the fact that fees in this case have been over $7,000 a day. So it just goes to show kind of, as Jill used the term, the wild, wild west nature of these SEC receiverships. You're not entirely sure what you're going to get into when these cases are initially filed. Next slide, please. And I will turn this over to Jill to discuss another example.
So this one was an extremely large SEC receivership out of the Western District of New York, and in it we had 90 plus multifamily properties that were sold or refinanced by a strategic buyer. The SEC receiver actually played a very minimal role in that case and allowed secured creditors to be paid in full on the debt, including fees and interest. And notably, certain secured creditors were not required to accept assumption of loans. So in my case, my clients did not want to do business with the new strategic buyer, had real concerns, rightfully so, and we said, no, we won't permit assumption. So those properties were ultimately sold and paid off by the buyer as opposed to the loans being assumed. We're talking billions with a B of secured indebtedness involved in that case. So you can see even large cases, if handled appropriately by a receiver, can go quite smoothly. And not some of them go off the rails, and some of them are done very professionally. Next slide. So let's talk about asset disposition. How does the receiver has a pot of funds? Where does it go, and how is it disseminated among the various investors and creditors? So essentially, the court's job is to ensure that the distribution is fair and reasonable. And we all know the terms fair and reasonable are subjective. And so the court has broad discretionary authority to make a decision and whether the distribution is permissible under the circumstances, which, and essentially anything goes. What I have seen typically is that investors will be paid more than unsecured creditors, which may receive a de minimis amount. So if you're a contractual counterparty, you may be left, with little to nothing, or there may be just a specific pot of funds set aside, say $50,000, that is set aside simply to pay unsecured claims. Secured creditors, again, Andrew talked about the disposition of the sale of the collateral, which you may be forced to take a haircut on, unfortunately, rather than foreclosing. Next slide. One issue is some courts have a local rule which provides that receivership should be administered akin to bankruptcy cases, but there's an important caveat, which is the court can use its discretion to shape how a case is administered, including the formation of a reorganization plan. So if you go into the court saying there's this local rule that says that bankruptcy principles apply, note that there are notable exceptions to that general rule, and the court will fashion whatever remedies it feels is appropriate. Next slide. So let's talk about the differences between a receiver plan and a bankruptcy plan. Again, there's no statutory requirements. It's just fair and equitable, and compare that with 11 USC 1129. There's no creditor solicitation and voting, so you won't be given an opportunity to vote. There's no one impaired class of claims that needs to approve it. It's simply you have the opportunity to object. There's no disclosure statement. There's no participation by the DOJ through the U.S. Trustees Program, only the SEC, and the SEC will weigh in on that plan to determine if it feels it's in the best interest of investors, not creditors. There's no absolute priority rule, meaning that equity could get paid out before unsecured claims are paid in full. And then the other issue is, would you receive administrative claims priority for goods and services provided post-receivership? It's debatable, unlike as you would have the case in a bankruptcy case. Next slide. Asset disposition. I'm going to turn it back over to Andrew.
Thanks, Joe. So ultimately, the assets of the estate will most likely be sold, and then the proceeds will be distributed pursuant to the claims process. Next slide, please. And so I just want to discuss a few of the considerations related to the sales of the assets. So there's case law that says the receiver cannot sell properties when the property is underwater, and should instead let the secured lender foreclose. Well, that's all well and good, but we go back to the same issue that these cases can be very unpredictable. This case out of Utah took the hard line that any property that was underwater should be abandoned by the receiver so the lender can foreclose. Next slide, please. However, the case that Jill and I are involved in has had the exact opposite outcome. The receiver has been entitled to sell over 100 properties that were encumbered by secured creditors' liens that were underwater, and now is holding the sale proceeds and not paying off the lenders. So again, it goes back to it's a very unpredictable process. You do have case law, but it's up to the discretion of the court. And here the court has determined that it will allow the receiver to proceed with those sales despite extensive objections and hearings on the issue. Next slide, please. There are some standards related to the disposition of real estate. The standard is that the terms and the manner that the receiver determines most beneficial to the receivership, and with due regard to the realization of the true and proper value of the property. So effectively what that means is the receiver is supposed to, one, consider how beneficial the sale will be to the estate, and two, is the sale going to garner the best value for the property? Next slide, please. And there are two ways that properties are sold, either via a public sale or a private sale, and those are governed by Section 2001. The public sale is what you would normally think of when you're conducting a foreclosure sale by advertisement. The statute does say it's supposed to occur at the courthouse, but there are nuances to that because the court can ultimately set the parameters, and a lot of times it's done through a sealed bid process. And it is similar to a private sale, but it's not a true private sale. And 2001B actually accounts for a true private sale. And there, the receiver can sell the property via broker in a private sale, but there are additional requirements that must be met. There must be 3 appraisals performed. That's very specific and has been upheld by courts throughout the country. The sale price must be at least 2/3 or more of the appraised value. And then there must be an opportunity for overbids. So the receiver will publish notice of the sale terms and sale price, and there must be an opportunity for overbids to be submitted. And the sale will not be confirmed if there's an overbid of 10% or more above the private sale price. Next slide, please. One thing as a secured lender you might be wondering is, are you able to credit bid? And a credit bid is your ability to bid the amount of your debt in lieu of actually paying cash to purchase the property. So the short answer is yes, but the long answer is there are strings attached and it's very nuanced. So one instance that we've run into is you might be able to credit bid, but only if you post a letter of credit in the amount of your credit bid. You might be able to credit bid, but the amount of your debt might not be determined before you credit bid. So you would risk a potential overbid. So what I mean by that is you submit a credit bid thinking that you have a secured lien for, let's just say, $2 million, but in the claims process, it's ultimately determined that your lien is only 1.5 million. Well, now all of a sudden you have an overbid of $500,000, and you didn't know that when you submitted your credit bid, so you might be out of pocket $500,000. Going back to the letter of credit, there were issues related to the timing of letter of credit, what the draw triggers would be, and so you could have the ability to credit bid, but it might not be as clean as you're normally used to. Next slide, please. And this just kind of is an overview of what we've already rehashed, is the theory versus practice. The receiver can sell the property. There should be protections for the secured creditors. However, it's much more nuanced in actual practice. There might be limiting timeframes for the credit bid. The property might be sold to an affiliate of a property manager. You might have restricted access to due diligence. We had a receivership sale that occurred during COVID, so there were restrictions on people traveling. There were restrictions on how many people could be at the property. And ultimately, the sale is very difficult to overturn, because if you try and take it up on appeal, well, your collateral has been sold, so your appeal could potentially be determined moot. Next slide, please. And I'll turn it back over to Jill.
And so I briefly wanted to talk, we're just about at the end of our time, about civil and criminal forfeitures and the interplay between them and the SEC receivership. Often where you find one, you'll find the other. And in one particular SEC receivership, we saw offshoots of civil and criminal forfeitures, which a forfeiture proceeding is simply one where the government comes in and seizes assets. So, and they're sold pursuant to sheriff sales and special procedures. So one of the things that I would advise is keep your ear up and search for, if you have an SEC receivership, have someone check federal dockets to make sure there aren't concurrent or also parallel forfeiture actions, because you need to protect your rights and get involved in those as well. And we have a whole white collar team that specializes in that, but that's something to think about as well. It's not just the SEC receivership. Oftentimes the SEC receiver will be working hand in glove with the DOJ to dispose of those particular assets. Next slide. So in summary, what are the key takeaways? Is these proceedings are not typically for the faint of heart. You won't see and have a predictable guideline for treatment. Even, as I mentioned, it varies court to court or even case to case. And that similar principles also apply in non-SEC federal equity receiverships. So what you're learning about today has a broader application than just SEC receiverships. But I did want to point out that you do have remedies, you can enforce them. The concept is you need to make sure that you're familiar with the order and how the process works and the equitable nature of the proceeding. Next slide. With that, I'll turn it over to Andrew for final comments.
Sure. Thanks, Jill. We just want to thank everyone for attending today. We hope that you found the presentation informative and useful. And we welcome any questions if people have any.
And of course, if anyone has any questions, feel free to reach out to us. It was our pleasure talking with everyone today. Thank you.